Breaking news. There's an accident that happened at Tamun Berhad Circuit involving a very famous motor racing driver, Timun. He has now have been transferred to the hospital due to severely injured. Let's take a look on this video that have been recorded through the live television.
What is this? Why is this happening? Why? Timon, my boyfriend. Oh no! My son! What's happening? I feel sick.
So, a lot of issues have been arise from this case, and it had been a very hot topic to be discussed. Today, in the BBC News, we have invited 5 professional lawyers to talk and try to resolve this matter.
Now I'm going to present about the first issue in this case, which is whether Timun may claim damages from Tamun Berhad due to their negligence. Negligence means the failure to do something that a reasonable man would do or do something that a reasonable man would not do. In order to help that the defender had been negligent, the claimant must be able to prove 3 elements. The first element would be duty of care, which is ascertained by 3 stages test, consists of foreseeability of harm, proximity of relationship, and whether it is just, fair and reasonable to impose such a duty on the defendant. The second element would be breach of duty by the defendant, which means defendant had acted below the standard of a reasonable man. The last element is causation, which can be further divided into causation in fact and causation in law. It is reasonably foreseeable that Timun will suffer physical injury if Tamun failed to provide a sufficiently safe and well-maintained track for the competition and repair the pothole immediately. There is also proximity of relationship between Tamun as the owner of the circuit and Timun as the participant of motor racing competition. Tamun would have foreseen that Timun will suffer further physical injury due to their negligent act. It was also just, fair and reasonable to impose such a duty on Tamun Berhad due to their negligence, as they failed to reduce the risk of foreseeable physical injury. Besides that, Tamun also breached their duty that they owed to Timun. They have the obligation and responsibility to ensure that the track was in a good condition and repair the pothole as soon as possible to prevent the accident. Thus, they have breached their duty as the owner of the circuit. And for the causation, it had been mentioned that Timun hit a pothole on a poorly maintained track. So there's a question arises. But for Tamun breach of duty, will Timun suffer injury? So here we can assume that the answer is no. Because Tamun breach of duty may result in damage or injury to Timun. If Timun is able to tender evidence to prove that the pothole was the factor which actually caused him to unable to control the vehicle properly, then he will be succeeded in his claim as he is able to prove the factual causation. Causation in law has to be determined by direct consequence test, which means the physical injury suffered by the plaintiff, which is Timun, is reasonably foreseeable as a direct consequence of Tamun Berhad negligent act. That's all from me. Thank you.
Thank you for the invitation. So next, another issue that we can raise is whether Kangkung and Kobes can claim for nervous shock from Tamun. Before that, let us know what is a nervous shock. Shock is all form of mental illness, neurosis, and personality change that are medically recognized. In order to claim for nervous shock, there are several requirements that need to be fulfilled. First and foremost, it must be foreseeable that plaintiff will sustain psychiatric illness due to his close relationship of love and affection with the primary victim. can be seen from the case of McLevin and O'Brien, where the plaintiff husband and 3 of the children were involved in a road accident caused by defendant negligence. The court held that the plaintiff entitled to claim for the damages, because it is foreseeable that a wife and a mother were affected due to the close relationship. There must be a physical proximity between plaintiff and the victims in terms of time and space. If plaintiff suffered nervous shock after the accident had happened and he not present there, then he cannot claim for the nervous shock. This requirement has been laid down in our court and Chief Constable of Yorkshire Police, where the court had dismissed the case. This is because the court found that the defendant did not owe duty of care towards the plaintiff, and besides that, the case was brought by 16 people, including some of who were at the stadium but not in the area where the disaster occurred. The shock must be caused by actual sight or sound of the immediate aftermath. Immediate aftermath explains that the accident and the death must be one single event and not separate distinctive events. The claimant must suffer the psychiatric illness immediately after witnessing the incident. This can be seen in the Broad and Nottingham General Hospital NHS Trust, where plaintiff's daughter had suffered overdose of paracetamol, and some at a point she developed high pressure in the brain, and monitoring board was inserted. Because of defendant negligence, plaintiff's daughter died. The court held that her parents cannot claim for the nervous shock, as the parents did not suffer the trauma immediately after witnessing their daughter's condition. The psychiatric illness must be medically recognized. It is only relevant for a person to get treatment by a doctor and the injury he suffered is recognized. If the person just claimed that he suffered nervous shock without any proof, then his claim may not be succeed. In Hinks and Barry, the plaintiff saw the incident after hearing a car crash, and she saw her husband was seriously injured and died on the spot, and most of her children suffered injuries. She later developed prolonged morbid depression. The court held that she was entitled to recover damages because she had a recognizable psychiatric illness caused by the breach of the duty of defendant.
In order for Kangkong to claim for the nervous shock, she needs to fulfill the first requirement, which is having a close relationship with the victim. In Kangkong case, we can clearly see that Kangkong and Timun are having a very close relationship, as Timun is her son. This is very similar to the case of McLevin and O'Brien, where it is reasonably foreseeable that a person who has a very close relationship with someone will be suffered from nervous shock when she lost her husband and child in a car accident. So we can see that Kangkong will be highly affected when her son is involved in a car accident which broadcasting live stream through her television. For the second requirement, which is having a physical proximity within a reasonable time and space. By referring to the Alcott case, the claimant failed to claim for the psychiatric illness because the event did not happen within a reasonable time and space and the claimant was just a mere bystander. However, in Kangkong case, the event happened during a live stream which are broadcasting to her television, and even though she has no proximity in space, but she was watching the accident within a reasonable time. Thus, we can conclude that Kangkong saw every horrible and tragic images of her son that is sufficient enough for her to suffer from the nervous shock. For the third requirement, the shock must happen immediately after the incident. In the case of Brook and Northampton General Hospital NHS Trust, it was stated that the parent cannot claim for the psychiatric illness because they did not suffer from the trauma immediately after watching her daughter's condition. This is very contrary to Kangkong case, where Kangkong suffered from the nervous shock immediately after watching a live stream which broadcast the accident involving her son. For the last requirement, the person must have been medically proven by a psychiatrist. By quoting from the case of Hinks and Barry, the court held that she can claim for a nervous shock because it was medically proven by a psychiatrist. Hence, we can assume that Kangkong has sought a treatment from an expert, and it is medically proven that there is an evidence that proves she is suffering from the nervous shock.
It's a very different story with Kobis. In the case of Kobis, she will not succeed in her claim for nervous shock due to several reasons, and to know the reasons why we must go through back to the requirements. So, let's see the first requirement. The first requirement talks about a close relationship, or we can call it as emotional relationship. So, Kobis did not have any close relationship with the primary victim, Timon, even though she claimed that she has the children with him. This is due to that she did not have any legal relationship, as she is just a girlfriend, not a spouse. It is unforeseeable for Kobis to suffer from any nervous shock because her relationship with Timon is not very close and affectionate enough compared to Timon's mother. So basically, the second requirement talks about physical proximity. In Kobis' situation, the fact that she did not present at the place when the incident happened and does not witness the incident in front of her own eyes had terminated her right to claim for nervous shock. This is because her situation is very contradicts with the AKMAL case, which require the one who had been suffering from nervous shock to be on time and place where the incident happened. The third requirement basically talks about the immediate aftermath. In this situation, the nervous shock that Kobis suffered is not immediate. This is because she did not see the actual accident and only saw Timon badly injured and was waiting to be treated at the hospital. In this situation, it is very similar with the case of Rock against Northampton General Hospital and HS Trust. As in the case, the plaintiff, which is the parents of the primary victim, cannot claim for nervous shock due to they did not suffer from the nervous shock immediately after the incident. The last requirement talks about the medical evidence. Although she, which is Kobis, claimed that she is a girlfriend of Timon, that is still not sufficient enough to claim for mental disorder. In fact, Kobis is just a girlfriend, and the loss that she felt cannot be compared to anyone that has a close relationship to Timon, such as his parent or his boss. Thus, we can assume that Kobis did not suffer from any critical mental disorder due to Timon's accident.
Hello everyone. Today we are going to talk about rescuers, referring to the case of Savi versus Tambun Berhad. What are rescuers? The law of torts describes rescuers as a person who got hurt or put in peril due to negligence or intentional wrongdoing of a defendant and gets injured in the process of the rescue. So the original wrongdoer is responsible in damages for the rescuer's injury. Based on the rescue doctrine is that rescuers as a class, that it is always foreseeable that they will willingly help defuse the situation and that they are owed a duty of care by the defendant when the defendant's negligence endangers or puts anyone at risk, including himself. According to Chadwick versus British Railways Board, a plaintiff witnessed a terrible railway accident and went to the scene. When he went to the scene to rescue the victims, he suffered nervous shock, and the court held that the plaintiff succeeded in his claim for nervous shock. However, for policy consideration, the court is reluctant to grant damages for rescuers who are firemen, policemen, and so on. So the application in the case of Tambun Berhad, we have to determine whether Savi's claims for nervous shock as a rescuer can be brought and succeed against them in negligence. Savi is a fireman who was called to the scene of the tragedy that happened to Timon in an accident due to the negligence of Tambun Berhad. As owners of the circuit, they failed to provide a well-maintained track. When Savi got called to the scene, he fell into the state of nervous shock because he got so affected by what he has seen and he has been unable to work since. It is indeed reasonably foreseeable that because Tambun Berhad created a situation where it invites rescuers like Savi to come and help aid in the situation. However, Savi's claims for nervous shock against Tambun Berhad would not succeed. One of the reasons is because, based on policy consideration, the court will be reluctant to grant damages for rescuers like him who is a fireman. Besides that, Savi is not a primary victim of the accident and also not directly involved in the accident. Therefore, in this case, Savi cannot sue Tambun Berhad for the claims of nervous shock and Tambun Berhad will not be held liable. Thank you very much.
Sadly, we have come to the end of this discussion, and if you have any questions to the lawyers, don't forget to visit our official website. See you next time.